So it looks like we're going to be headed to the Fourth Circuit with the Walker open carry case. It blows my mind that now we have a court order that mentions specifically camouflage pants in regards to whether or not somebody could possess a gun or not without looking like a criminal. And also discussing AR-15s as if they're in a separate category as any other firearm, such as a shotgun or a pistol. I mean, it's just there's no basis in the law in the state of West Virginia. So it looks like we're headed to the Fourth Circuit in that case, and it just brings up the point that there is such large misunderstanding of gun rights, of the Second Amendment, and it goes all the way through to the federal judiciary. So it begs the question, really, what is the Second Amendment? The Second Amendment itself is pretty simple. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now that seems pretty straightforward. And, why does it mention militia? Well, when the Second Amendment was ratified in 1791, each state had its own militia law. Virginia, for instance, had the Virginia Militia Act, enacted May 5th of 1777, and it was very specific that every non-commissioned officer and private had to have a rifle and tomahawk or a good firelock and bayonet with a pouch and horn or a cartouche or cartridge box and with 3 charges of powder and ball, and moreover, each of the said officers and soldiers shall constantly keep 1 pound of powder and 4 pounds of ball to be produced whenever called for by his commanding officer. So that was required by law, that you had to have not only your own tomahawk and firelock or musket or rifle, you had to have extra powder, 4 pounds of lead balls. You had to have 1 pound of powder. And if any soldier, if any citizen who falls under this age range is certified to be so poor that he cannot purchase these items himself, then he's essentially given welfare. He can borrow the public arms from the public store at the expense of the public. However, it has to be brought back, and if he doesn't bring it back, he gets 39 lashes. Now, that was the Virginia Militia Act. So that was the nature of our society when the Second Amendment was passed. So naturally, the people were armed. And that's why the states did not want to join the Union where the new federal government could disarm them. They didn't want just a federal armed force and disarm the states themselves, who acted through the individuals who were armed. So fast forward to where we are today, or at least as of 2008. When I went to law school, they basically taught you that the Second Amendment meant nothing, that it only applied to the states, that it did not, or it only applied to the federal government, rather, and that it had never been incorporated to the states, which was a bunch of garbage. And it remained that way until 2008, after I was out of law school, in the case of District of Columbia versus Heller. And so really that was the first time any of us had any Second Amendment rights, at least according to the United States Supreme Court. And so when the Heller Court looked at this very simple sentence in the Second Amendment, it broke it down into 2 different clauses. The first part, a well-regulated militia being necessary to the security of a free state. And that was called the prefatory clause. And then they said that the rest of it was the operative clause, which is the right of the people to keep and bear arms shall not be infringed. And this was discussed in the Heller case in 2008 by the U.S. Supreme Court. Essentially, Heller found that the Second Amendment does protect, or it does give citizens the right to keep and bear arms in their own home, at least a pistol, unfortunately. Now, there's disagreement about whether that applies to things like AR-15s, but at least to keep and bear arms, at least a pistol, in one's own home. That's really all Heller says. And the The question is whether that would be expanded outside the home. It hasn't happened yet. The next big Supreme Court case that came down was the McDonald case. I believe that was in 2012, that you have the right to keep and bear arms in your home is applied to the states. It's not just applied to Congress as it's written in the Second Amendment. And why is that? That's because we had another constitutional amendment called the 14th Amendment. And that had to do with fixing all the problems that we had from slavery and the Civil War. And it said that basically we have to treat everybody equally, equal protection under the laws, and so on. So that's been, that is the source of all these Bill of Rights, how they're applied to the states and not just the federal government. And that's always been through the 14th Amendment. Even inside the home, they can still restrict your Second Amendment rights. For instance, in Maryland, they passed an assault weapons ban, and that's the Colby v. Hogan case from 2017. And it was challenged on the basis of the Second Amendment. And the Fourth Circuit said that, well, we're not convinced that Heller extends to the evil, scary black rifle, the AR-15. We think they're just talking about handguns. And really, it's an awful decision. And, if you want to read it, read it. You probably should. But take your anxiety medicine before you read that decision. That's Colby v. Hogan, Fourth Circuit, 2017. The Second Amendment, unfortunately, has not been interpreted to mean what it is written to mean. There are all sorts of, as you'll hear Mike Bloomberg say in his prepared remarks on gun control, there are reasonable restrictions which have been allowed and which are legal and restricting the Second Amendment. Although I disagree with that, and I think a lot of people disagree with that. But we have allowed this through the years, long before I was born, and we've had restrictions on felons owning guns, on domestic violence protective orders, removing all the guns from your home. So mental health restrictions. So, it's just the way it is. And so restrictions have been allowed. So what happens in practice is that the Fourth Amendment saves the day, and it comes in white knights the Second Amendment. Because if you have no Second Amendment rights outside of your home, then what are we depending on? All we have is the Fourth Amendment. And so almost all of gun rights law are all Fourth Amendment cases. And a lot of those, and really the majority of those, are probably criminal cases. So indirectly, you have all these criminal defendants to thank for developing this body of law that, somewhat protects any gun rights outside the home. So what do you need to know about the Fourth Amendment as it applies to gun rights? Well, it all goes back to 1968. That's all you need to know, really, is Terry versus Ohio. If you've ever heard of a Terry search, that's where it comes from. 1968, it was the Warren Court, notoriously pro-law enforcement, and I believe that Warren's son maybe was murdered or something like that, and he was just super pro-police and just crushing the rights of the citizens. And this is when New York was still so dangerous, and there were switchblades walking around all over New York City, and everybody was the bad guys were armed, and they started the stop and frisk stuff. So that's it. That's where this came from. That has collided with the reality of all these states across the United States liberalizing gun laws, where now you have constitutional carry in West Virginia and other states. You have concealed carry rights, which have been greatly expanded. But you have the federal judiciary, which has been continuing to put this Warren Court stop and frisk standard on the Fourth Amendment to suppress the Second Amendment. And really outside your home, remember the Second Amendment applies inside your home, as per Heller. Outside your home, there is no Second Amendment right now. So it's all the Fourth Amendment. So Terry versus Ohio basically says that police, if they already have reasonable suspicion to believe that you may have committed some crime, and you're in an encounter, what's called a forced encounter, usually a traffic stop between a police officer and a citizen, the police officer has the right to do a quick search of any area or clothing where there could be a hidden weapon for safety purposes. And that's called a Terry frisk or a Terry sweep. And it's technically not to search for evidence of a crime, even though it is. It's for safety reasons. So if you read a lot of the search and seizure case law, it turns on, well, is that a spot that was accessible to the individual? Was there a safety reason? So that is where we have collided the Fourth Amendment with the Second Amendment. So the courts have continued to expand Terry searches, while especially the red states continue to liberalize gun rights. So they're going in different directions, such as West Virginia. Now, West Virginia is in the Fourth Circuit, and we have had some awful cases recently in the Fourth Circuit. 2017, U.S. versus Robinson, Fourth Circuit case, and that directly goes to Terry searches. And in that case, they noted that to do a Terry search, an officer generally has to have some suspicion that the person is armed and dangerous. So they see a firearm. But it used to be that they had to also think that the person was dangerous, not just armed. Well, in U.S. versus Robinson, the Fourth Circuit went ahead and cut out the middleman and said, guns are dangerous. Therefore, if a person is armed, that person is dangerous for the purposes of evaluating whether a Terry stop is justified. But that applied only in vehicles. So what that means is right now, at least in the Fourth Circuit, and this hasn't been addressed by the United States Supreme Court, if you are in a traffic stop and a police officer knows that you are armed, even if it's a lawfully possessed and owned weapon, even if it's carried in a lawful way, the police officer then can disarm you and can proceed with a Terry search or run your background check and all that, just for safety reasons. Even though obviously this is used for to gain evidence of criminal behavior to use in prosecutions. So that is what U.S. v. Robinson did, and it basically takes the Fourth Amendment away from anybody who's lawfully armed inside a vehicle that's already subject to a traffic stop. Now, there still in that situation is reasonable suspicion because you have to have had a lawful traffic stop to begin with, which requires reasonable suspicion. It doesn't take much with a traffic stop. It could be, I noticed that his tag light was out, he had a brake light out, or he went left of center, or he went right of the line. I mean, it could be any number of things. It even could be a lie. But at least on the record, there's already reasonable suspicion. So where this does not apply is to somebody open carrying. And that brings us to exactly what's happening in the Walker case. Because right now in the Fourth Circuit, there's a really good case from 2013 called United States versus Black. And that was written by Justice Gregory, who I have had the honor of appearing and arguing before and back in 2013, the same year as the U.S. v. Black case. And in that case, it found, and this was in a racial context in North Carolina, but that case found that just because you see, a black guy in a high crime area who is open carrying a firearm, you cannot stop that person, get their ID, and run their background check because you don't know, you have no legitimate reason to suspect that that person has committed any crime. You can't go off the skin color. You can't go off of just the gun because North Carolina, like West Virginia, is an open carry state. So there's no proper basis for you to perform that stop. There's no real reasonable suspicion. That also protected us in West Virginia because we also are an open carry state. And if you read the dissents in U.S. versus Robinson, which really are better than the opinion, which is awful, Judge Gregory writes a dissent that specifically mentions West Virginia and how law-abiding West Virginians will be punished or could be punished by going down this road of assuming that anyone armed is also dangerous. because the West Virginia legislature has concluded that it trusts its citizens, that West Virginians are always free, or mountaineers are always free, and we're going to trust them to open carry firearms, to concealed carry firearms, to have firearms. And we can't automatically assume, as a matter of law, as a categorical rule, that that person is dangerous because of the firearm. So what they're trying to do now in my Walker case is apply the awful rule from Robinson that anyone with a gun is automatically dangerous as a matter of law to anyone open carrying. But the problem is now they have to also include the creation of reasonable suspicion into that scenario because there's no traffic stop. So it looks like that's what they're trying to do in the Walker case. That's where they're going with this. That's what they'll have to conclude if they go that route. But that's, and again, that's only the Fourth Circuit. But you'll see that the United States versus Robinson case is cited in other circuits. So the reality is that you have more gun rights as a pedestrian than you do in a car, which is silly, which is absurd, but that's just the way it's panned out. There are other good cases from other circuits which are helpful to people looking to assert their gun rights, protect their gun rights. Another good one is, other than the U.S. v. Black case, is Northrop v. City of Toledo Police Department from 2015, and that's the Sixth Circuit, and that's from Ohio. And they came really to the opposite conclusion as the Robinson Court in the Fourth Circuit, where there was a guy, and again, I think he was a black guy, open carrying, and really this is tied in with civil rights. If you look at the history of gun control, where did it originate? And they were suppressing minorities. That's what they were doing. But you had a guy open carrying, somebody called police, you said you can't do that, you can't have a gun. Well, open carry was legal in Ohio, not as broadly as West Virginia. So you still had to jump through a couple hoops, but potentially it was legal. So we get really an opposite case in Northrop with a non-categorical and an individualized analysis for a Terry search, for a Terry stop. And that's the way it was supposed to be anyways. If you think this person is not only armed but dangerous, you need to be able to articulate why. You can't just say it's a gun, guns are bad, therefore he's armed and dangerous. So in Ohio, they got really a better result. They got this, requirement that you have to articulate individualized reasons why this person is not only armed but dangerous, and therefore I need to disarm him and check his ID and all that, which is what we're complaining about here. Just because you are open carrying a gun or concealed carrying a gun without evidence that you're a criminal or you've committed some crime, you should not be disarmed and subjected to background checks or whatever the officer wants to do. Another good case, United States versus Leo, that's Seventh Circuit, and it puts restrictions on gun searches, and that was out of Wisconsin. And basically, you had, and again, you'll see that the common thread here is they're trying to, it's affecting minorities. Here you had two Hispanic men wearing hoodies, and they kind of looked suspicious. According to the 911 caller, she thought they may have robbed this place and they were headed, somewhere else to do something bad. And she said one of them has a gun and actually says his revolver is in his backpack. So this officer observes, what the 911 caller complained about, and it was corroborated by what he saw. The only problem was there wasn't really an armed robbery. They had the right to go in this apartment they went in. And they really weren't doing anything wrong other than he had some weed in his backpack and he had this revolver in his backpack. So the officer basically stops the guy with the backpack, and he puts him in handcuffs. And once he's in handcuffs, he searches backpack and he finds the revolver and finds the weed. He gets arrested, he gets prosecuted, and it goes all the way up to the Seventh Circuit. And they found that, no. If you are performing a Terry search, remember that's supposed to be for officer safety reasons. So if the guy was already handcuffed, there's no officer safety reason for you to search his backpack. You can search his backpack, but just like any other search, you need probable cause. So whereas the only information the officer had was that he had a revolver and it was in his backpack. So that's not probable cause that any crime was committed, because that, may have been completely legal. And there was no officer safety reason to search that backpack because the guy was already handcuffed. So, that's another case to look at. Another one of the rare U.S. Supreme Court cases is the Jael case of Florida versus Jael, and that's from 2000. And that's where the state of Florida tried to get the court to recognize a firearm exception to Terry searches. And so that dealt with an anonymous tip where it was alleged that this guy had an illegal gun that would be found, and the court basically looked at, as they do with anonymous tip cases, the reliability that the anonymous caller has. Is there any corroboration to what they're saying? Has this person been used before? Do we know who it was? And were they credible? Were they reliable? Can you articulate why that was reliable? So the U.S. Supreme Court expressly declined to adopt a firearm exception to the standard Terry analysis. So that's another good case which can be cited in these firearm cases. The last one I'll talk about, United States versus Ubeliz. I'm not sure how you pronounce it, but that's a Third Circuit case from the year 2000. And another anonymous tip case. This was in the Virgin Islands. There was an anonymous tip that this guy, Mr. Ubeliz, or however you pronounce it, that he possessed a firearm at a public event. But there was no indication or information that he was engaged in or planning to engage in any illegal activity. It was just the gun itself, kind of like a lot of these cases. The court held that the mere possession of a lawful object, such as a gun, where you're allowed to possess a gun, unless you're a prohibited person, but they didn't know that, does not entitle a police officer to infer criminal activity in the absence of reasonable articulable suspicion of some other criminal conduct. And the court in that case actually analogized that to carrying a wallet. Inferring that somebody is a criminal because they have a gun is like inferring that anybody with a wallet is also a counterfeiter because they may have counterfeit bills in that wallet. So again, another good case to cite and to look at for these Fourth Amendment cases, but really it's very incomplete. And so we've got this clash between state legislatures increasing gun rights and the federal judiciary going down the same road they've been going down since 1968 of decreasing individual liberty and increasing the rights of police officers to search. So, this is as good as the progress has been for Second Amendment rights, for gun rights in individual states like here in West Virginia. There's a big battle to be fought, many battles to be fought in the federal judiciary where gun control proponents are seeking to go around the state legislatures and create new gun restrictions in areas that otherwise are getting more and more free. So that's the current state of your gun rights, your Second Amendment rights in the United States, and especially in the Fourth Circuit. And hopefully now you realize that it all has to do with the Fourth Amendment rather than the Second. Now hopefully we'll get a Supreme Court case expanding Second Amendment rights beyond the home. But until that happens, really the only protection we have is the Fourth Amendment.